So basically, you explained us the highlights, how these legislations, the new legislations as well as judiciary, they, I mean, converse with each other and sort of develop, modify the jurisprudence around online liability. So, what are the key highlights amongst these services that Indian government can look at, or whether can we assume, safely assume, that these legislations or these models which we saw, which we hear in the EU market, is can set a good precedent in terms of how India can modify the online liability framework?
Yeah. Well, I would first like to take the opportunity to say that actually what we are seeing in terms of the judiciary and some of the legal decisions of late, really positive developments, where clearly the courts have recognized the problems that that right owners have in terms of enforcement their rights, and some very, very positive, robust decisions on, in particular, in terms of injunctions against services whose services are used to enable, if you will, piracy from outside India. So that's really great news, and in that respect, India is very much at the kind of cutting edge of the legal developments. But then, in terms of the if you will, the policy developments, again, I would like to say that if we are just looking at the sort of the liability framework as such, my interpretation of the existing rules is that in terms of, if you will, the rights that exist, they are there. India has recently, or relatively recently, signed the WIPO Internet, as they are called, the Internet treaties, the 1996 WIPO Copyright Treaty and Performances and Phonograms Treaty. So they are there. So really, I think the focus is, or should be, to take a very hard look at the liability exemptions, the privileges that you have in the IT Act in Section 79 today, and look whether they are fit for purpose and whether they are interpreted and applied in a manner that is still fit for purpose in today's environment, which is very, very different from the time when these safe harbor provisions were first introduced internationally and in India. And that comes back to something we discussed previously. The first thing is to look at the scope of those safe harbor provisions, that ensure that they are only applicable to truly technical, automatic, and passive services. So the likes of, let's say, short form user uploaded content services that rely on the distribution of content should not be eligible for the safe harbors. And that's what the legislator in the EU has said very clearly. So that's number one. And then number two is, as we discussed also, is that those services that are eligible for these privileges or immunities, that those immunities and privileges come with robust conditions. So in order to enjoy, to be eligible for those privileges, you should take credible action to ensure that content that has been detected to be infringing, and normally it would be the right owners that notify these services of such infringements, that content is removed from the services or networks expeditiously. And then there are measures put in place that ensure that the content does not immediately come back. So notice and stay down. Notice and mere takedown is no longer, it's not satisfactory, and it is not fair because of the volumes and the speed of the distribution of content on these services. And then there are other issues like credible know your business customer rules, and ensuring that there's cooperation with the stakeholders, with the right owners, in terms of disclosing then the information about the operators, so that right owners in appropriate cases can pursue direct legal actions if that's possible and appropriate.